Many people think that the estate planning documents that we create should have a ton of detail and nuance and context and intentionality in them in terms of how things should be done by the trustee, the executor, or any number of different fiduciaries, maybe even guardians of minor kids. But the legal documents themselves are generally an inappropriate mechanism to deliver instruction. They're meant to be legal authority documents, the ability to give authority for people to act, or the ability for people to have the authority to benefit from your estate or from your trust. And so often we will instruct clients to create what are called letters of intent, memorandums of intent, those sorts of things to basically inform the intention of how things are supposed to be done. And so that could be any number of different purposes. It could be how to continue raising your children if they are still minors, like the school they go to, the pediatrician they go to, the types of activities you want to promote, the travel and visitation to grandparents or aunts and uncles, where they should live, those sorts of things. And that's effectively instructing the guardian on what your goals would be for the children in the event that they're still minors. When it comes to wealth transfer, we're often instructing a trustee on how they're going to use their discretion for appropriate expenses, like where the kids go to college, what type of car should be purchased for them, how much to provide for things like a wedding or a down payment on a house. Those are all really important intentions or pieces of context for a trustee to consider when they're using their discretion for expenses for the beneficiaries. And when they have clarity around what your goals are, they'll be more confident in their actions when they align with your goals. They'll have some CYA to fall back on in the event that somebody disagrees with them. Those are all what we call precatory instructions, meaning they're not legally binding. They're not required or mandatory, nor should they be, because the trustee may not be able to comply with those sorts of things, or it may not be safe or appropriate for some of the things that you feel are appropriate to be done in that moment. So they're meant to be guidelines and instructive intentions for the trustees, for the guardians to utilize in making their decisions in that moment.